Morning. Go ahead and state your process.
Good morning, Your Honor. Ariana Reed on behalf of the carrier plaintiffs.
Good morning, Your Honor. Elizabeth Lowell on behalf of Milwaukee Instruments defendant.
Good morning, Your Honor. Brianna Switzler, bar number 15653 on behalf of the Wren and the Cava plaintiffs.
Good morning.
Good morning, Your Honor. Chad Fears on behalf of the Hannah and the Sid entities defendants.
Good morning.
Good morning, Your Honor. Aaron Machenbacher on behalf of Costco Wholesale Corp.
Good morning.
Good morning, Your Honor. Jim Kavanaugh with Gordon Reese on behalf of Real Water of Tennessee, LLC.
Good morning.
Eric Freeman on behalf of Real Water and Infinity Lifestyles.
Good morning. Not hearing anybody else. So hopefully that's everyone. I've reviewed the Milwaukee Instruments motions to amend in the three cases. I'll tell you what I'm inclined to do, and I'm inclined to grant them. And I guess one question I would have, for the opposition once your turn, it seems, well, let me give you reasons and then the question for when's your turn, I guess. So they certainly appear to be timely. NRCP 15A, leave to amend should be freely granted when justice so requires. They do not seem, although I can understand why leaves being sought to cross T's and dot I's is how I kind of characterize it here. But it doesn't seem like they, would substantively change, anything in terms of discovery or trial strategy or anything like that. They're more of a, belt and suspenders approach to what's already been asserted as affirmative defense or defenses. So there's that. But then in addition, this goes maybe to the question, following that, what's the harm or prejudice to allowing it when it's, here it's not a, hey, we never asserted any affirmative defense vis-a-vis this punitive damages claim. That's again more belt and suspenders kind of thing. So it's not really like a surprise, and I'm not sure how there could be harm or prejudice. So I'd like to hear about that once your turn. But Ms. Lowell.
Thank you, Your Honor. I'll be brief. We were asking to amend 3 complaints in 3 different cases. They're now consolidated. 2 of the cases.
Let me pause. Sorry. But go pause you because I forgot. I've got a big note up here. When you said consolidate, so when in the consolidated cases versus the coordinated, consolidated, you can just file one, motion or what have you. So just, going forward, that's what you can do. And I meant to say that at the beginning. The coordinated, yeah, it's different because they're only coordinated, they're not consolidated. So I apologize, I totally interrupted you. Please continue.
And I was about to apologize.
Oh, no,
I think 3 motions. I saw Real Water has filed a very similar motion, and they did it much more elegantly
Oh,
with just three different exhibits of their proposed amendment.
Okay.
So we understand, and, sorry for the paper.
That's okay.
So the defenses are all the same. Plaintiffs are represented, two of the cases they're represented by Kemp Jones, which would be Miss Switzler, and one of the cases they're represented by the Campbell Williams law firm. But we want to we originally have this defense which says an award of punitive damages against this answering defendant would be unconstitutional under applicable constitutional protections. We believe that really is all we need. This motion was filed kind of in a response to arguments by the Kemp Jones counsel, which is counsel here, in other coordinated cases, saying you have to assert a specific annihilation defense in order to present evidence of your financial condition in the event you are liable as a defendant for the second phase of punitive damages. So we just want to make sure, Milwaukee is a small company. It employs 5 people. Its financial statements will show that it's a very small company. And we are just doing everything we can to make sure that we can, in the event that we're found liable for punitive damages, we can present that information. To the extent that the court were to deny the motion and say, well, this is all duplicative, you already have this ability to present financial condition evidence under NRS 42.005 and, your constitutional defense, that would be fine with us too. So we thought this was the best way to bring this issue in front of Your Honor. And if you don't have any questions, I will reserve time.
Sure. No, thank you. And I don't know who wants to go first in opposition, you or Ms. Switzler, or?
I'll defer to Ms. Switzler.
Okay.
All right, I believe I heard that I'm up. Good morning, Your Honor.
Good morning.
I heard your inclination this morning and I understand your question. I think the basis of the motion is just to clarify an abundance of caution, but there is the annihilation kind of component to it. We have filed our expert reports as the opposition as their reply, I'm sorry, typically used to do the other way around, as the reply has indicated. We filed our expert reports already with the timing of our rebuttal reports or anything like that kind of upcoming soon. So to the extent that this isn't duplicative and just isn't a belt and suspenders, it kind of is unclear to us exactly. While it appears duplicative, I don't know if they're trying to, if there's any other avenues that they can pursue on top of that. And so that's kind of where the prejudice comes in, as far as, our close of discovery is in about a month and a half. Expert reports have been provided already, initial expert reports. While I appreciate, Milwaukee presents it as a small company, I think that is an argument for a later day, and some questions as far as conglomerate it's a part of 125 companies, and just kind of how this plays in with the trial proceedings as it relates to the disclosure deadlines and the discovery as it relates to that.
Thank you very much. Ms. Reed.
And we join in the CAVA and Wren.
Thank you. Any rebuttal? If you say no, that's okay.
I would just simply say that the financial statements that I spoke of were in the coordinated cases. They were produced in a disclosure in June to the Kemp Jones law firm, who was representing other plaintiffs, right? And they were also disclosed in this case on December 29th of 2023. So
okay, thank you. So I'm going to stick with my initial inclination, grant the motions to amend the answers in the 3 consolidated cases here. They are timely filed. There's no harm or prejudice to plaintiffs. under NRCP 15A, leave to amend shall be freely given when justice so requires. The punitive damages affirmative defense already having been asserted. This is whether you call it clarification, belt and suspenders. This is not a out of the blue case changing, whether trial or discovery proposed amendment. And so Grant, for those reasons, include in there, so this is with the caveat that I'm not going to say you can do this or that, but you can include in the order to address a potential concern. If, emphasis in if, appropriate experts are under certain circumstances permitted to supplement reports. That may or may not apply here. Just put that in there. That way, if I need to deal with it at some point in the future, I'll be reminded of my statement today. Put the reasons in there, circulate to everyone for review and approval.
Can I just, so include if necessary, the appropriate experts would be permitted to supplement the reports.
If you're comfortable with that stronger language than I just said, you can certainly include that.
No, I'd rather have your language.
Okay.
I was reading it really carefully.
So if you need what I just said, see Mr. Yarborough right there for a
Okay.
copy of the video or the transcript.
Okay, thank you.
Thank you. That's it, right, on this one?
Yes.
Thank you all.
Thanks, John.
That's everything. Thank you, Your Honor.